of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. That means the High Court, in exercise of revisional power, will vary or reverse any order only if the condition that the order, if it had been the other way about, it would have disposed of the suit or other proceedings. Otherwise not. Of course, revisional power can be exercised in respect of interlocutory proceedings as well. But varying or reversing, this is the criteria. Now, this was not alone the provision here. A portion was deleted by the amendment, which is that deleted portion. This order, if it had been in favor of the party applying for revision, would have finally disposed of the suit or other proceeding, is there already in the proviso. That was clause A of the proviso. Then there was a clause B, which is the order, if allowed to stand, would occasion a failure of justice or cause irreparable injury to the party, against whom it was made. This was deleted, with the result that only if the three conditions are satisfied, plus the order, if it had been the other way about, it would have disposed of the suit or other proceeding, that condition also should be fully satisfied. Sorry. That is the crux of the amendment. That clause B was deleted. What is the purpose? And it was subject matter of discussion in Salem Advocate Bar Association case Salem 2, paragraph 40. Salem 2, paragraph 40 and Salem 2, paragraph 40. Let us see what is this. Paragraph 40. After stating what was contained in what section 115 did contain, the aforesaid clause B stands omitted. The question is about the constitutional powers of the High Court under Article 227 on account of omission made in section 115 of the Code. The question stands settled by a decision of this court in Suryadev Rai versus Ramchandar Rai, that is 2003 6 SCC 675, holding that the power of the High Court under Article 226 and 227 of the Constitution is always in addition to the revisional jurisdiction conferred on it. Curtailment of revisional jurisdiction of the High Court under Section 150 does not take away or could not have taken away the constitutional jurisdiction of the High Court. The power exists untrammeled by the amendment in Section 150 and is available to be exercised subject to rules of self-discipline and practice, which are all well set. What happened after the amendment? The purpose was to reduce the number of litigation, reduce stagnation, and the chance of people rushing to the High Court at every stage and getting stay of the proceedings and protracting the trial of the case. That was the purpose, laudable purpose. But what happened ultimately is that people started filing original petitions under Article 226. So even an adjournment petition, when rejected, a stage came, people used to flock to the High Court, rush to the High Court. But Supreme Court has mentioned that rules of self-discipline is there, and therefore only in exceptional cases the High Court will exercise the power of revision. But this power, constitutional power under Article 227, is not taken away by the amendment of section 100. Thereafter, there is another decision of the Supreme Court which says that a writ petition will not lie. That one view was that even a writ can be filed to quash an order passed by the subordinate court. Later, that was not accepted, and the Supreme Court said that it is original petition, not a writ petition. Now it is being numbered as OPC, OP civil or OP criminal, whatever it is. Now we go to the next provision, section 148. What is section 148? 148. 148 is enlargement of the period already granted. Enlargement of time. What are the conditions necessary? Where any period is fixed or granted by the court. Granted by the court for doing any act prescribed or allowed by this court. The court may in its discretion from time to time enlarge such period not exceeding 30 days in total, even though the period originally fixed or granted may have expired. By the amendment, this ceiling of 30 days in total is introduced. Before that, it was not there. Any number of days the court could extend, enlarge. Suppose there is a direction to deposit arrears of rent. That was not deposited. Say 1 month's time was granted. That time expired. Even thereafter, party could apply. Court could grant in the facts and circumstances of the case. In appropriate cases, the court could exercise the discretion of granting more time. But that is curtailed by the amendment, that the maximum period that can be granted under section 148 is 30 days in total. Any number of times the court may extend, but it should not in total go beyond 30 days. This is the amendment. Now, how the court considered it? Salem 2, paragraph 41 to 43. Court held that section 151 can be resolved. After that period of 30 days, there is no provision. That means that there is a vacuum. The court can exercise the power under section 151 inherent powers and extend the period if necessary in appropriate cases. This is what is held. Paragraph 41 to 43. Before amendment, there was no restriction. Whether the court has no inherent power to extend the time beyond 30 days is the question. We have no doubt that the upper limit fixed in section 148 cannot take away the inherent power of the court to pass orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. The rigid operation of the section would lead to absurdity. Section 151 has therefore to be allowed to operate fully. Extension beyond the maximum of 30 days thus can be permitted if the act could not be performed within 30 days for reasons beyond the control of the party. This is what is held by the Supreme Court. Further down it is there. I read only the crux of it. So that in appropriate cases, the court can extend time. And after this period, in total 30 days is over, the court retains the power under section 151 of the CPC. Next provision is Order 5, Rule 9. Order 5, Rule 9. Order 5 is service of summons that underwent drastic change. Now courier service, email, personal service by the plaintiff against the defendant, and all those things were introduced with all good purpose. But some apprehensions were raised that courier service, how it should be effected and all those things. The Supreme Court in Salem 2 discussed the matter in paragraph 27 and 28. 27 and 28. 27, one sentence I will read. The apprehension expressed is that service outside the normal procedure is likely to lead to false reports of service and passing of ex parte decrees. This was voiced. The court said that there is appropriate checks and measures. Non-service of summons has been the major causes of delay, Supreme Court noticed. Court shall have to be very careful while dealing with a case where orders for deemed service are required to be made on the basis of the endorsement of such service or refusal by the courier. High courts can make appropriate rules. Filing of an affidavit was introduced. The deponent can be the affidavit shall be in the language known to the deponent. It can also be provided that if an affidavit or an endorsement as to services is found to be false, the deponent can be summarily tried and punished for perjury, and the courier company can be blacklisted. All these things were said. So that sufficient protection, high courts can make rules. And some of the states it is working properly nowadays. If in commercial transactions, particularly between two businessmen or business groups or companies and all those things, email and all those things are recognized methods. But where the parties are peasants and workers in villages, all these things may not work, but sufficient safeguards are there. Otherwise, personal service is required, the court can say that. So flexibility is there. Now, next is Order 7, Rule 11. What is Order 7, Rule 11? Rejection of plaint. Salem 1, paragraph 16. Salem 1 I have mentioned, 2003 decision. The other is 2005 decision. Salem 1, paragraph 16. Reject the plaint. There are clauses E and F added by the amendments. And where it is not filed in duplicate, plaint shall be filed in duplicate. Or where the plaintiff fails to comply with the provisions of Rule 9 of Order 7, that is producing sufficient number of copies. It appears to us that said clauses being procedural would not require the automatic rejection of plaint at the first instance. Sufficient opportunity should be given. If there is defect, the court should ordinarily give an opportunity of rectifying the defects, etc. In Order 18, Rule 4, I'm sorry, this is what is said. Order 7, Rule 9. Now, Order 8, Rule 1. Order 8 is written statement. Order 8, Rule 1. What happened in 99? 99, it was provided by the 99 amendment, it was provided that the written statement shall be filed within 30 days from the date of service of summons. And the advocates mentioned, I mentioned in part 1 that there was discussion all throughout India, and the central government was informed, and this matter was considered again by the parliament, and certain relaxations were made, certain changes were made and reintroduced, and both these acts came into force on 1/7/2002. Now, what is Order 7, Rule 11, which I mentioned? Order 7, Rule 14 next. Order 7, Rule 14. We'll deal with it next. What is Order 7, Rule 14? Salem 2, paragraph 34. Salem 2, paragraph 34. Order 7, Rule 14. Order 7, Rule 14 says that the plaintiff shall produce all the documents within his power, along with the plaint or within such time as the court prescribes, and the penal consequences if it is not produced, it cannot be received in evidence. All those things are stated in Order 7, Rule 40. Now, if you have got the CPC with you, please take that. Order 7, Rule 40. Order 8, Rule 1, I will come to it. Order 8, Rule 1, we have already dealt. Order 7, Rule 14. A document which ought to be produced in court by the plaintiff when the plaintiff is presented, that document cannot be produced later. Nothing in this rule shall apply to documents produced for the cross-examination of the plaintiff's witness or handed over to the witness merely to refresh his memory. This was considered by the Supreme Court, and the objection was that there is a mistake in drafting. Instead of the plaintiff's witness, it must be defendant's witness. And what is said by the Supreme Court, let us see. Order 7, Rule 14, paragraph 34 and 35. In paragraph 35 last, it is mentioned that paragraph 34 last, it is evident that the words plaintiff's witnesses have been mentioned as a result of a mistake that seems to have been committed by the legislature. The words sought to be defendants, the words ought to be defendant's witness. There is a similar provision, Order 8, Rule 1A4, which applies to defendant. After stating so, the Supreme Court said in paragraph 35, to avoid any confusion, we direct that till the legislature corrects a mistake, the words plaintiff's witness would be read as defendant's witness in Order 7, Rule 14.4. We, however, hope that the mistake would be expeditiously corrected by the legislature. Now, I committed a mistake. I started Order 8, Rule 1, then I abruptly went to Order 7, Rule 40. That is because the seriatim I have mentioned. Therefore, I had a doubt and confusion. Now we come to Order 8, Rule 1. Sorry for the difficulty caused to you. Order 8, Rule 1. The amendment in 99 was that the return statement shall be filed within 30 days from the date of service of summons. Then, when this objection was raised by the bar, the Parliament again considered it, and the maximum time limit of 90 days was provided. Then the question arose, what will happen after 90 days? Let us see what is the amendment. Provided that present a return statement of defense within 30 days. That is so. That is even now it is so. Provided that where the defendant fails to file the return statement within the set period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. Not later than 90 days. This created difficulty. The question arose whether the court has power in a given case to accept the return statement which is filed beyond 90 days, or whether court is bound to pass a decree if it is otherwise grantable, taking it that there is no return statement. This was the question considered, and it is answered in paragraph 14 to 21 of Salem 2. Salem 2, 14 to 21. Let us see the relevant portion, 14 to 21. Very relevant portion, otherwise there will be no time. Yes. The question is whether the court has any power or jurisdiction to extend the period beyond 90 days. The maximum period of 90 days to file the return statement has been provided, but the consequence on failure to file the return statement within the set period have not been provided for in Order 8 Rule 1. The point for consideration is whether the provisions providing for maximum period of 90 days is mandatory, and therefore the court is altogether powerless to extend the time even in exceptionally hard cases. This was the question considered. Along with this, there is another provision which is to be considered. Order 8 Rule 10. Order 8 Rule 10. Order 8 Rule 10 provides that where a party from whom a written statement is required under Rule 1 or 9 fails to present the same within the time permitted or fixed by the court, the court shall pronounce the judgment against him or make such other order in relation to the suit as it seems fit. So, what is the consequence is also mentioned in Order 8 Rule 10. Supreme Court interpreted it meticulously. Supreme Court said that it is not always necessary that when no return statement is filed within time, if the plaint should be as such decreed, as if there is no defense. It is not so. The court may in appropriate case pass such orders. Therefore, there is flexibility, and therefore it is only direct, not mandatory. This is what is said in paragraph 21. In construing this provision, support can also be had from Order 8 Rule 10. Then further down, in construing the provision of Order 8 Rule 1 and Rule 10, the doctrine of harmonious construction is required to be applied. The effect would be that under Rule 10 of Order 8, the court in its discretion would have power to allow the defendant to file the written statement even after the expiry of the period of 90 days provided in Order 8 Rule 1. There is no restriction in Order 8 Rule 10 that after the expiry of 90 days, further time cannot be granted. There is no such restriction. The court has wide power to make such an order in relation to the suit as it thinks fit. Clearly, therefore, the provision of Order 8 Rule 1 providing for the upper limit of 90 days to file the written statement is directory. Exceptionally hard case, only in exceptionally hard case, the court will grant time. The Supreme Court also took precaution and said that the courts will take. And in paragraph 20, it is mentioned the word shall in by itself is not conclusive. And the Supreme Court referred to 3 decisions of the Supreme Court in paragraph 17, 18, and 19. One is a constitution bench decision, the others are not. And all these principles in 1965 Supreme Court, 55 Supreme Court, and 2002 Supreme Court were discussed in other paragraphs, earlier paragraphs, up to 20. So these are the portions with respect to Order 8 Rule 10, Rule 1. I'm taking it to some extent fastly because there are other portions also to be covered. Order 9 Rule 5. Fresh summons shall be taken if service is not effected. Fresh summons shall be taken by the plaintiff and it shall be done within 7 days. That is a provision, Order 9 Rule 5. And that is discussed in Salem 2, paragraph 44. Salem 2, paragraph 44. Yes, the period of 7 days mentioned in Order 9 Rule 5 is clearly directory. Conclusion is in one sentence, discussion only in one sentence. The period of 7 days mentioned in Order 9 Rule 5 is clearly directory. This is what is said by the Supreme Court. Therefore, it is very clear that the court can always grant time in appropriate cases. Next is Order 11, Rule 15. Order 11, Rule 15. Salem 2, paragraph 45. The stipulation in Order 1, Order 11, Rule 15, confining the inspection of documents at or before settlement of issues instead of at any time is also nothing but direct. It does not mean that the inspection cannot be allowed after settlement. Inspection of document. Discovery and inspection is the heading of Order 11, and there the court has power to direct a party to allow the other party to inspect documents, and the party can do it and thereby avoid delay in disposal of the matters. And there the restriction is, which is sought to be introduced by 46, the stipulation that is at or before settlement of issues. That is said that it is only directory, even after that it can be done. Next provision which is relevant is Order 18, Rule 2. Order 18, Rule 2. Salem 2, paragraph 32. Salem 2, paragraph 32. Order 18, Rule 2.4, which was inserted by Act 104 of 76, has been omitted by Act 46 of 99. It was introduced in 1976 by way of amendment. That was taken away in 1990. Under the said rule, the court could direct or permit any party to examine any party or any witness at any stage. So by deleting it, what the parliament thought, that the parties always rush to the court, come to the court with a request to examine a party at a belated stage, and thereby the process of trial is protracted. Now, what the Supreme Court said, before 76 it was not there, that provision was not there. What were the court doing? The courts were allowing it in appropriate cases. That position will continue. Even prior to the insertion of Order 18, Rule 2.4, such permission could be granted by the court in its discretion. The provision was inserted in 1976 by way of caution. The omission of Rule 18, Order 18, Rule 2.4 by the 1999 amendment does not take away the court's inherent power to call for any witness at any stage, either suo motu or on the prayer of a party invoking the inherent powers of the court. Order 18, Rule 2. Paragraph 32. Order 18, Rule 4. Next is Order 18, Rule 4. Salem 1. This is very important. Order 18, Rule 4. Salem 1, paragraph 17 to 19. 17 to 19. Salem 2, 5 to 12. Paragraph 5 to 12. Salem 1, paragraph 17 to 19. Salem 2, paragraph 5 to 12. I will read the relevant portion in Salem 2 now. Then thereafter I will go to the other portion. This is very important and practical application. 5 to 20, 5 to 12. And the Supreme Court considered in Salem 2 not only Order 18, Rule 4, but considered Order 18, Rule 19, Order 26, Rule 4A, and certain other provisions, because these are all interconnected. The amendment provides, Rule 4 provides that in every case, the examination in chief of a witness shall be on affidavit. There is no difficulty. The court has already been vested with the power to permit affidavits to be filed as evidence as provided in Rule 19 of Order 19, Rules 1 and 2 of the Code. It has to be kept in view that the right of cross-examination, re-examination in open court has not been disturbed by Order 18, Rule 4 inserted by the amendment. Therefore, the court has a discretion. Affidavit can be insisted. Then further the court said, an apprehension was expressed by the lawyers that if a witness is summoned, not produced by the party calling the witness, summoned by the court, how can the affidavit be insisted? The Supreme Court said, in such cases, the court may examine him, allow the party to examine him in chief and cross. There is nothing wrong. And the scope of Order 8 Rule 4 has been examined in Salem.bar. There is also no question of inadmissible documents being read into evidence merely on account of such documents given as exhibit numbers in affidavit filed by the examination chief. This is another apprehension. Examination chief practically verbatim reproduction of the plaint and plus the documents which the plaintiff produced. An apprehension is raised that there may be inadmissible documents. There may be unregistered documents which are inadmissible. There are documents which are not sufficiently stamped, even if registration is not required. And such things may be there. What will the court do if the affidavit is filed? There also the Supreme Court said, provide so to sub-rule 2 of Order 4 Rule 8 clearly suggests that the court has to apply its mind to the facts of the case, nature of allegation, nature of evidence, and importance of the particular witness for determining whether the witness shall be examined in court or by the commissioner appointed by it. And it also said that inadmissible document being read merely on account of such documents being given exhibit numbers in the affidavit filed by of examination. Further, in Salem Advocate Association, one case it has been held that the trial court in appropriate case can permit the examination chief to be recorded in court. So all these safeguards have been provided. Then the Supreme Court considered Order 18 Rule 5. Please see Order 18 Rule 5. Order 18 Rule 5 says, how evidence shall be taken in appealable cases. On reading of Rule 5, which was not touched by the amendment, and it is retained in the CPC even after of 2 amendments, 99 and 2002, what it says is that in appealable cases, the evidence of each witness shall be taken down in the language of the court in writing or in the presence or under the personal direction and superintendence of the judge, or from the dictation of the judge directly on a typewriter. If the judge, for reasons to be recorded, so directs, the recorded mechanically in the language of the court. So a judge's presence is always required by Rule 5. So it was argued that there is a contradiction between Rule 4 and Rule 5. Then the Supreme Court answered, please see Rule 19 of Order 18. Power to get statements recorded on commission. There is such a provision. Order 26 Rule 4A, Supreme Court considered along with this. And it was said that in appropriate cases, the court can issue commission. I will rather read what the Supreme Court said. Only the important aspects. In paragraph 7, amendment to Order 18 Rule 5A and 5B was made in section 6. It is provided that in all appealable cases, evidence shall be recorded by the court. Order 18, Rule 4 was amended by the Amendment Act of 99 and again by Amendment Act of 2002. Order 18, Rule 4.3 enables the commissioners to record evidence in all types of cases, including appealable cases. The contention urged is that there is a conflict between these provisions, and that conflict was resolved by the Supreme Court. That contention was resolved by the Supreme Court in paragraph 8 and 9. Rule 19 was referred to, power to get statements recorded on commission. And it is said in paragraph 8 that the aforesaid provision contains a non-obstante clause. It overrides Order 18, Rule 5, which provides the court to record evidence in all appealable cases. The court is therefore empowered to appoint a commissioner for recording evidence in appealable cases as well. Further, Order 26, Rule 4A, inserted by Amendment Act of 99, provides that, notwithstanding anything contained in these rules, the court may, in the interest of justice, or for expeditious disposal of the case, or for any other reason, issue a commission in any suit for the examination of any person resident within the local limits of the court's jurisdiction. Order 18, Rule 19, Order 18, Rule 19, and Order 26, Rule 4A, in our view, would override Order 18, Rule 5A and B. Therefore, these provisions which were introduced by way of amendment will override Rule 5 of Order 18. There is no conflict. It will override. Then para 10, next question has been raised about the power of the commissioner to declare a witness hostile. There the solution is also mentioned in paragraph 10. The direction to declare a witness hostile has not been conferred on the commissioner. What should be done in such cases also mentioned. The court's order should be taken. If a situation as to declaring a hostile witness arises before a commission recording evidence, the party concerned shall have to obtain permission from the court under section 154 of the Evidence Act. And it is only after grant of such permission that the commission can allow a party to cross-examine his own witness. Then in paragraph 12, it is mentioned how the original documents should be dealt with by the commissioner appointed to record it. What are all the things to be done? So Order 18, one of the major amendments in 99 and 2002, and the challenge therein, not only on the ground of constitutionality, but on the ground of inherent contradictions with some of the provisions already existing, all resolved by the Supreme Court in Salem 1 and 2. Order 18, next is Order 18, Rule 17A. Order 18, Rule 17A. And it is discussed in Salem 1 at paragraph 20 and 21, and in Salem 2, paragraph 30. Let us see Salem 1, para 20, 21. And what is this? Amendment of 76, Rule 17A was inserted in Order 18, which gave an opportunity to party adduce additional evidence under circumstances mentioned. Such a provision was not there. It was introduced in 76 by way of 76 Amendment. Supreme Court asked, what was the circumstances before 1976? What was the court doing before 76? Court in appropriate cases could grant such a request. Now that is a position. In spite of deletion of that particular rule, court still has power to grant it. The remedy, if any, is that available to a litigant with regard to adducing additional evidence prior to 76 would be available now and no more. Salem 2, paragraph 13. What does it say? Reference is made to Salem 1. Same thing is said. court could had inbuilt power to permit parties to produce evidence not known to them earlier or which could not be produced in spite of due diligence. Order 18 Rule 17A did not create a new right but only clarified the position. Therefore, deletion of Order 18 Rule 17A does not disentitle production of evidence at a later stage. On a party satisfying the court that after exercise of due diligence, that evidence was not within the knowledge or could not be produced at the time of party was leading evidence, the court may permit reading of such evidence at a later stage. Therefore, the Supreme Court solved that problem also. Next is Adjournment Order 17. Salem 2, paragraph 29 to 31. Paragraph 29 to 31. Supreme Court said Order 17 does not forbid grant of an injunction adjournment where the circumstances are beyond the control of the court. By the amendment, the court's power was restricted that maximum at the request of a party, maximum adjournments can be granted at only three times, not more. Court said there may arise situations where it is necessary. That is considered in paragraph 29, 30 and 31. In paragraph 30 it is said, so read, Order 17 does not forbid grant of an adjournment where the circumstances are beyond the control of a party. In such a case, there is no restriction on the number of adjournments to be granted. Further down, for instance, a party may be suddenly hospitalized on account of some serious ailment, or there may be serious accident or some act of God leading to devastation. If it cannot be said that though the circumstance may be beyond the control of a party, further adjournment cannot be granted because of the restriction of 3 adjournments as provided in the proviso to Order 17.1. In some extreme cases, it may become necessary to grant adjournment despite the fact that 3 adjournments have already been granted. Take the example Bhopal gas tragedy, Gujarat earthquake, and riots and devastation on account of tsunami. Ultimately, it would depend upon the facts and circumstances of each case. Court has power. That is what is said. It is not ideal to restrict, curtail the power of the court. Court should have powers. Whether it is exercised to be exercised in a given case is a different thing. It is in the discretion of the court. The court will not go astray. Court is experienced. Court is legally trained, and it is the court's exercise of such power are all regulated by decisions of Honorable Supreme Court and various high courts. Therefore, that danger of the judicial officer going, saying that I got unbridled powers, it is not so. Court has powers. And on the other hand, if a legislation restricts the powers, you shall not do that. You have no such power. That is not good for the society. What cannot be, the legislature cannot foresee all the circumstances which may require to be applied in a given case. Supreme Court has said in paragraph 30 and 31. Now, Corona. Supreme Court extended their period of limitation. How many times? All these cannot be foreseen. Therefore, don't make a law which takes away the powers of the courts at all times. Whatever may be the circumstance, you have no power beyond 30 days. You cannot extend beyond 30 days. Written statement cannot be accepted after 90 days. Or adjournment cannot be granted more than 3 times. These are all such provisions in terror. It is not good for the society. And that is why Supreme Court said, while appointing a committee, the creases are to be corrected. Ironed out. Creases are to be ironed out. And that was done by the committee, and that was considered by the Supreme Court in great detail. And it was said that these are all directory These are mandatory. These are not mandatory. It can be applied in extreme cases. Court retains the power. In spite of a particular provision being there, it said that after the expiry of that period, there is no provision. Return statement, therefore, 148, extension of time. Therefore, the court can exercise the power under 151. Who takes away the powers of the court under 150? Civil court has that power. Criminal court does not have, except the High Court under 482. The subordinate criminal courts do not have the power which is akin to section 151 CPC. Many think that the civil courts do not have powers. It is not correct. Civil court has wide powers. And the judgments and decrees of the civil courts will be bound. The criminal court will be bound. On the other hand, civil court will not be bound by the judgment of the criminal court, except that what is the result, who are all the parties, what the court did. That's all binding thing, not the reasoning or other things. Next is Order 41, Rule 9, Salem 1, paragraph 22 and 23. Salem 1, paragraph 22 and 23. Registry of Memorandum of Appeal. Rule 9 provided that of Order 41, the court from whose decree an appeal lies shall entertain a memorandum of appeal and shall endorse thereon the date of presentation and shall register the appeal in a book kept for that purpose. Such book shall be called the Register of Appeal. What was the intention of the legislature is nobody knows it. Probably the parliament thought that the appropriate provision must be made so that the party's difficulties can be avoided. If he is defeated in the trial court, he can present the appeal in that court itself, which is to be filed in a far away place court. Maybe that. But Supreme Court said that appeal is to be filed in the court where it is to be filed. But all that is meant is that a copy of the appeal memorandum should be kept in the file of the trial court. A copy should be provided to the trial court. That's all required. Merely because a memorandum of appeal is not filed under Order 41 Rule 9 will not in our mind make the appeal filed before the appellate court a defective one. Only that is required, that is that a copy should be provided. That's all. All filing in the appellate court. Otherwise, filing in the trial court itself will not do good. Suppose an urgent matter of stay is required. What will the trial court do? Trial court has to transmit their accounts. It will take time. On the other hand, if a trial court's decision is rendered and after getting copy, the party can rush to the appellate court, get an emergent order. That will be taken away if this Rule 9 is strictly compliant. The appeal should be filed in the trial court itself. If it is optional, it is all right, but it is not so. Therefore, the Supreme Court interpreted like this. Now, with that, we come to an end of these provisions, important amendments, and I hope, yes, 5 minutes to 10. We can type because. So, thank you very much. We'll meet again, time permits, on some other occasion with some other subject. Yes, thank you.
As they say that it will continue the knowledge sharing, the way you simplify things is just mesmerizing. And the way you want to take things forward, that is another thing to be understood. And there are so many topics and so many things to be learned from you. How to maintain balance between an active life, how to simplify things, and how to maintain that the session which you take forward is actually comes to an end within the time frame. To understand the entire gamut of the topic and then bringing it, narrowing down in a structured manner is a thing which can always be learned from you. But as I say, practice makes the man perfect. And your art of perfectionism in that aspect is too fascinating to be understood and followed.
Thank you. Thank you.
You have made things so clear, at least on the chat we don't have. I will just check it out as to whether we have any question on the YouTube. No, so it's only thank you coming forth. So we part for the day today, and we will have the sessions coming forth. We are also starting a service law series with Mr. P.S. Rajagopal, where we will take around 15 sessions on different issues. And same way, we'll be also taking a contract law series by Professor Nilima Farfade. So stay connected with us on the social media. And needless to add, we have already taken so many sessions with Justice K.T.Sankaran, and his sessions will continue. We will discuss with Justice K.T.Sankaran so that rather than taking topics here and there, we will try to see that all things go in a chronological manner from now onwards. Everyone stay safe, stay blessed, and take precautions, as some numbers of COVID has also started increasing. And they say the prevention is better than cure. So keep on taking preventive measures, and the way we have been able to sail through, we are quite sure that we will continue to survive and do betterment for the society. And the most positive part of these testing times were we have been able to connect with people like Justice K.T.Sankaran, who are full of knowledge, and the most interesting part is that they are willing to share. Everyone stay safe again and stay blessed. Thank you. Namaskar.
Thank you, Mr. Vikas and the participants. Thank you.